express agreement. Second, where it is the products, where the computer output is the products of an approved process. And third, I can prove it is reliable. I just spent a bit of time on the first one. Express agreements. What exactly is express agreement? It can be, well, it is, as the name suggests, expressly agreed between parties, right? It can be initiated if the agreement was obtained by fraud, duress, mistake of misrepresentation. And the catch is this: in criminal proceedings, if the accused person is unrepresented at the time the agreement is made, it is not valid. Now the question now is this: can an express agreement be reached, or rather, I'll put it the other way, must an express agreement be reached for the specific case or for the specific trial for which the evidence is intended to be adduced? Or can we have this as a standard clause in a standard form contract between, before any dispute has arisen, between for example, a bank is saying that if any dispute arises out of this contract, then parties agree that the bank's electronic records will be admissible by agreement. So the question I leave everyone with is this: must the express agreements be confined to the trial or the case involved? The approved process I do not intend to talk about too long, because it is a very involved process. There are audits of the process, and eventually, once the process has been certificated, it will be it's easily admissible. What I'd like to turn our attention to is the third limb. The third limb is the one that we come across most frequently, where there is proof of reliability. Proof of reliability essentially means that you need to show that there's no reasonable ground for believing that the output is inaccurate because of improper use. That's the turn of phrase. Inaccurate because of improper use of the computer. The second limb is that there's no reason to exist or doubt or suspect the truth or reliability of the output. And then the third one is there's reasonable ground to believe that the computer was operating properly at all times. So I just very loosely refer to this third limb as proof by certification, or to certify that it is reliable. Now, there are two ways of proving reliability. One, you can prove reliability by adducing a certificate under Section 35(6) of the Evidence Act. I won't go into the details of the case law that has interpreted this limb. I'll leave that to Brian. But essentially, you don't need a computer expert to produce a certificate. Any person who manages the system, familiar with the operation of the system, will do. So that is a formal certificate that's produced and tendered. If there is no, if you do not tender a certificate, you can also satisfy these requirements by giving oral evidence, and that is clearly exemplified in the case of Benedict Ng and Zim integrated shipping. In that case, certificate wasn't tendered. Brian will talk a lot more about it in this section. All I want to say at this point, at this juncture, is this: in that case, the key thing to note is that oral evidence was given by the manager who sought to adduce the evidence, which was essentially a list of email addresses. He was familiar with the system. The computer system was a very simple system that he had full knowledge of. And the court observed that the threshold where a computer system is simple, not complex, is very low, very easily met. So the question now, which we will come back to later, is that if it is so easily met, does it take away from the or does it diminish the requirements of proof of reliability? Right? Classic example is if, let's say, we were to use a typewriter to type a letter, right? You call the author to adduce the evidence of the letter. If I use a word processor, a computer, to type a letter, technically, I need to call the author, and I also need to produce a Section 35 certificate. Right? But on the authority of Benedict Ng and Zim Integrated Shipping, it is now possible to call the author and adduce oral evidence to him without having to produce a Section 35 certificate. And since it is a notebook that I use very often, a simple printer, a simple processor, a simple system, then the threshold for admissibility is low. So, I'll leave us with those thoughts, and I'll hand the time over to Brian, and then we'll come back again to talk about this a little bit more.